Good afternoon once again, everyone. Well, thank you all again for being here. Certainly a pleasure to have everyone. A few years ago at our luncheon on Saturday, before we began the Rosencrantz debate series, we had a panel of federal appellate court judges talking about life on the bench. Internally, we called that panel bunch of judges, just the in-house sort of shorthand for it. And this is very similar to that panel. It's judges and former judges, or judges and a former judge, but with a particular focus on how life is changing at the district court level. So we've got district court judges, former district court judges, and of course, a very good friend of the Federalist Society to moderate from the Ninth Circuit, Judge Carlos Bea. He's a longtime friend of the Federalist Society. I count him as a personal friend, him and his wife Louise, and we're so very pleased to have him back with us again this year. So with that, please welcome Judge Bea.
Thank you very much, Dean. We have a distinguished panel here today, and the first thing I'll do is like to introduce the name of this session is The Evolution of the District Courts. And we have with us, on my immediate left, Tom Hardiman, who was born in Waltham, Massachusetts in 1965, and he received his BA honors from University of Notre Dame and JD with honors from Georgetown University Law Center in 1990. During law school, he served as a notes and comment editor on the Georgetown Law Journal. Following graduation, he joined the Washington, D.C. firm of Skadden Arps as an associate in the litigation group. In 1992, he moved to Pittsburgh and joined the firm of Sindrich and Titus, later known as Titus and Mukasey, as an associate. In 1996, he was elected partner at the age of 30. In 1999, Judge Hardiman joined Reed Smith as a partner in the litigation department until he took the bench on November 1st, 2003. To his left, Michael Mukasey, counsel to the firm, recently served as Attorney General of the United States, the nation's chief law enforcement officer. As Attorney General from November 2007 to January 2009, he oversaw the U.S. Department of Justice and advised on critical issues of domestic and international law. Judge Mukasey joined Debevoise as a partner in the litigation practice in New York in February 2009, focusing his practice primarily on internal investigations, independent board reviews, and corporate governance. From 1988 to 2006, Judge Mukasey served as a district judge in the United States District Court for the Southern District of New York, becoming chief judge in 2000. To his left, William Edward Smith is the Chief United States District Judge of the United States District Court for the District of Rhode Island. Prior to his appointment to the bench in 2002, Judge Smith was a partner at Edwards and Angel, practicing labor and employment law. And last but not least, on my left, Amul Thapar is the United States Circuit Judge for the Sixth Circuit, who has the privilege of being the first South Asian Article III judge. President George W. Bush nominated him to the district court in May of 2007, and President Donald J. Trump nominated him to the Sixth Circuit on March 21st, 2017. Before becoming a judge, Judge Thapar served as United States Attorney for the Eastern District of Kentucky. While United States Attorney, Judge Thapar was appointed to the Attorney General's Advisory Committee and chaired AGAC's Controlled Substances and Asset Forfeiture Committee. He also served on the Terrorism and National Security Subcommittee, the Violent Crime Committee, Subcommittee, and Child Exploitation Working Group. What we're going to talk about today is the dearth and perhaps death of civil trials and criminal trials in the U.S. District Court. To give you an idea of a little background on this, the proportion of civil cases concluded at trial in federal courts has steadily declined from about 25% in the 1930s. That's 25% of the cases that were filed went to trial. When I started practice in the early 60s, it was about 20% or 18 or 20%. It's now below 2%. State courts are faring even worse, with only 1% of state civil cases being concluded at trial. There has been a similar decrease in the absolute number of civil trials. The number of civil trials has decreased by more than 20% during a period in which civil filings have increased fivefold. Why is this? The Federal Rules of Civil Procedure, issued in 1938, seem to shift the focus of pretrial procedures from pleading to discovery, and to perform the function of investigation of facts that used to be done by the examination and cross-examination of witnesses at trial. The result is that facts are known now long before trial, but at great cost due to the complicated and excessive discovery techniques employed. District courts have become, in what one of my old colleagues from the Superior Court told me, she said, "We're not a trial court anymore in San Francisco, we're a law and motion court." They determine motions of summary judgment and class action certifications for resolution by multi-district litigation panels, or cases are referred to alternate dispute resolution, arbitration, or mediation. Yale professor John Langheim put it, pretrial procedure has become non-trial procedure by making trial obsolete. Or discovery is used as a tool to make litigation so expensive as to foment settlement. A certain amount of backlash has resulted in raising pleading requirements in the Iqbal and Twombly cases and in strict Rule 9 enforcement in claim fraud cases. The format today will not be the normal recitation by each one of these distinguished gentlemen, but will be a discussion of several topics, and they'll be able to chime in with their own views as we go along. One of the things that we're going to start with is Judge Smith, who's prepared a PowerPoint presentation to show you just what has been happening as far as the trials are concerned. Judge Smith?
All right, well, it's not so much a presentation, it's just a couple of slides so you can rest easy. So just these slides, which I hope you all can see, will just put a little bit finer point on some of the statistics that Judge Bay just recited to you, and give it to you in a little more visual format. So this slide shows the really inexorable decline in civil trials from 1962 to the present. And you see a peak there at about 1968. We were trying approximately 12% of civil trials, of civil filings. And now in the federal courts, we are under 1%. Now, this data is, I'm quite confident it's very accurate, but it all comes from the Administrative Office of the Courts, data collection, and there are some quirks about that, and I won't go into any of the details, but you can see this inexorable decline in both jury and bench trials. So we're under 1% now. Let's go to the next slide. Shows really much more of the story, and really an interesting story. So there's 3 lines here. The bottom line is the trial line that you just saw on the first slide, the declining trials. The two other lines, the orange line represents the percentage of matters that were resolved without any court action whatsoever. So in 1962, about 55% of cases filed in the federal district courts were resolved with no involvement of a judge. The blue line represents cases that were resolved with the involvement of a judge, including trials. And in 1962, that was about 35%, a little less than 35%. As you move along in time, and I put 2 call-out boxes there for 2 seminal events. One was the summary judgment trilogy, the Celotex trilogy of the Supreme Court in 1986, and the other was the Civil Justice Reform Act, which is the law that required all district courts to have an ADR, Alternative Dispute Resolution Program. And these events, you can see the lines crossing virtually at the point where the Supreme Court decided the summary judgment trilogy and then proceeding along. What's so interesting about this, I think, is, as you get to the next slide, is if you think about how many cases involve district court judges, it's now at around 82% involve judges in some way, motions to dismiss, motions for summary judgment, settlement conferences, or trials. We know that under 1% of that is trials. And then if we go to the next slide, we look at the caseloads of district court judges. They've almost doubled since 1971 from 311 pending cases per authorized judgeship to 628 cases per authorized judgeship. Now that doesn't mean that every district judge has 628 cases. Obviously we have senior judges and there's a lot of variation between and among districts. But as the numbers have gone up in terms of filings, the involvement of judges has gone up. And if you go back, I'll go back to the last slide and just point one thing out. If you look right here and you think about in 1962, judges only got involved in about 35% of the cases filed, and 12%, almost half, a little under half of that involvement was trials. This slide shows you the time to disposition of cases that actually do go to trial. And it's gone from 1997, 18 months, up to about 25 months now, which could represent, and we'll talk about this, perhaps the increasing complexity of the cases that do go to trial, perhaps the difficulty of discovery. And then turning to the criminal side, you can see here the number of cases going to trial on the criminal side has gone down from around 15% in 1962 to just over about 2.5% in 2017. And there are a couple of call-out boxes there just to give a couple of frames of reference. The Sentencing Reform Act, which was passed in 1982 and 1984, and the federal sentencing guidelines, which came into effect in 1987, and you can see how much the number of criminal trials declined after those two events. And finally, this is the flip side of these last two slides are the flip side of that. That is the number of cases disposed by plea agreement, which in the 1960s was around 83% and is now around 97%. And finally, the amount of time it takes for criminal cases to be disposed of in the district courts, which in 1971 was about 3 months and has now gone to about 7.5 months. So there you have it.
Now I'd like to ask the panelists from left to right what their impression is as to why this is happening. Tom?
Well, I think statistics that are that dramatic, sort of, obviously it's a multitude of factors, but I think the principal culprits are litigation has become too expensive and too slow. I've always believed that justice delayed is justice denied, and I think that judges are not always as proactive as they need to be in moving their docket. Sometimes it's judges that have an outlandishly large portfolio of cases based upon where they're located in the country. So there are great geographic disparities around the country depending upon what federal district court one works in. But in terms of things that we can change, I think discovery is a big problem. And perhaps we could do some audience participation here. How many in the room have tried a case? Raise your hand. Great. For those of you that raised your hand, for those who raised their hand, how many think that discovery is your favorite part of litigation? Okay, there's a gentleman in the back. Okay, thank you. Okay, and I know I hated discovery as a lawyer. I hated I wanted to get into the arena and try my case. I wanted to get a result for my client, preferably a good one, but even if it was a negative result, you wanted closure for your client, so your client could get on with his or her or its life. So I think we need to try to be creative and find ways to make discovery less burdensome, less expensive, and move the case expeditiously.
General?
Well, a couple of things. First of all, I find it somewhat interesting that, and it's the first time I've seen this, the greater the involvement of district judges in cases, the slower it is that they get resolved. Given the requirement under Rule 26 that you have a conference early on, you would think that the effect would be precisely the opposite. And part of that, I think, is that lawyers and judges are really no threat to try cases. It's simply become kind of part of the ritual that you go through. To the extent that law firm economics has contributed particularly to the decline of civil cases, I would call your attention to that statistic about the peak of civil trials being in 1968. I don't think there's anybody in this room who actually remembers 1968 other than me, but in 1968, well, there's one. In 1968, the New York law firm of Cravath, Swaine, and Moore raised starting salaries unilaterally to, brace yourselves, $15,000 a year. That was a 50% increase. In fact, there was a newscaster named Eric Severide who ended his newscast the day they did that with just that item, and did it in just that portentous way. $15,000 a year for first-year students. Obviously, that changed the economics for private litigants substantially, and it's gone upwards since then.
Well, a couple thoughts. One is that I think in some ways we're the victims of our own success. When we began seriously to pursue alternative dispute resolution programs in our courts, most courts took it very seriously, devoted a lot of resources to it, and actually became very successful at it. And I know this is true in my court, and I think it is true in many courts around the country. Lawyers respond to that in some ways, developing the way that the economic model of how they practice law starts to respond to the fact that we provide such effective mediation services. So there's a lot of cases that are filed by a lot of lawyers who know they're going to get a magistrate judge who works for free, who will invest an enormous amount of time in helping them get a case settled that they never intend to take to trial, and they're able to develop that into a very lucrative economic model of practice. So I think that's one thing, trials are very expensive and they're very chancy, and I think most lawyers would much prefer to work the case out on both sides, plaintiff's and defendant's side. So I think that's one factor. And the second is the trilogy that in 1986 really got lawyers and courts focused on summary judgment as a tool for resolving cases and really encouraged it. And so it has become almost standard in every case. Judge Hardiman and I were talking out in the hall beforehand, and we have to work hard to persuade lawyers, even in cases where there are clearly factual disputes, not to file summary judgment motions. We had a judge in my court who's passed away a number of years ago, but he had a saying that he would tell lawyers that, why do you want a summary judgment when you can get a real judgment? And that's the line I've stolen from him to tell lawyers, and very often they'll run off and settle the case before they get to trial. So I think those are the two main phenomena that I think has driven the numbers down. And the third one, I think it's very important too, is the rules of civil procedure and the Chief Justice have encouraged judges to be very proactive in managing cases. And so we are encouraged as district court judges to reach out and touch the case frequently. And of course, that leads to more discussion about what are you doing to resolve this case. So I'd say those three factors.
Judge Thapar?
So I agree with everything they said. I might have a little different take. So I look at the stats and the studies, and I see trials going up, time to resolution going down, and happiness of lawyers going down. So that, to me, seems consistent. No one went to law school to be a discovery lawyer. You never tell people I went to law school to be a discovery lawyer. You say I went to be a trial lawyer or a corporate lawyer. And the problem is, as everyone's identified, is litigation is too slow. Part of that is on the lawyers, and part of that's on the judges. So to me, what has to change, let me throw out an example. Does anyone know in here, other than the AUSAs and criminal defense attorneys, so the civil attorneys, does anyone know how long between indictment and trial you have to go in a criminal case? I can't hear anyone, so I'll just say it. What is it? 30 days, no, close. 70 days, right? And someone's liberty's at stake, and you're talking about 70 days between indictment and trial without a finding by the judge that there's an exception. So what we tried in Pikeville, which is a remote docket of Kentucky, is now 70 days into criminal trial. We tried in a civil trial 1 year. Complaint to trial, guaranteed 1 year. You're going to go to trial. I gave lawyers 3 months for discovery. You would not believe the screams at first. I said, here's the deal. I'm available day or night. I'm available 24/7. Any disagreement you have, I will resolve immediately. Let's not aim for perfect discovery. Let's aim for imperfect discovery and happy lawyers, happy clients. What people want is their day in trial. If you go back and look at, and Justice Thomas talks about this in some of his opinions, what the founders talked about with trials. Here's what John Adams said: representative government and trial by jury are the heart and lungs of liberty. Elbert Gary said, the jury is adapted to investigation of truth beyond any other system the world can produce. A tribunal without juries would be a star chamber in civil cases. People want a jury trial. And why don't we give it to them? For a number of reasons. Discovery takes way too long. People are trying for perfect discovery rather than quick discovery. Again, criminal cases, someone's liberty's at stake, 70 days. Civil trials, 25 months. There's something wrong with that. And the profession is getting unhappier. If lawyers, young lawyers, I met a young lawyer the other day who's here, who said she showed up at Will Consovoy's firm and was cross-examining a witness in the Harvard trial. I mean, how many young lawyers would die to have that opportunity? So something is wrong when we're dragging these things out. So to me, the resolution is shorter discovery, quicker trials. We had a lot more trials. We had a lot less discovery fights when you only have 3 months to get it done. The other commitment judges need to make, it's interesting to me, judges get involved in litigation drags out. The reason is judges are pushing, we were trained to push people to settle. Well, what message, in my mind, does that give to the clients coming to court? Here's a judge who doesn't want to do his or her job and try the case. And so the reality is we should leave dispute resolution to the parties. As judges, we need to try cases, but the other thing we need to do is resolve motions. So the commitment I made when I said, okay, I'm going to put you through this to get us to trial is 30 days from the minute a motion is ripe, I have to resolve it. Set deadlines in orders for myself to live up to. And I think judges need to start doing that, because if we're resolving motions quickly, you're not going to have the frivolous summary judgment motions because they know they're going to rule on it. What happens when I look at the final point I'll make, judges who are too involved, they're dragging out cases because they're interested in ADR and they're not resolving motions. You file a motion, it sits for 9 months because they're hoping you'll resolve it. If they have a deadline to resolve it, frivolous motions won't get filed because you'll get a ruling quick and we'll get more trials.
Michael, you had some experience with setting one-year limits to trials. You want to talk about that?
Yeah, the one key point that Judge Thapar just made when he was talking about the way discovery goes on, he says, I'm available 24 hours a day. It's interesting, he didn't say you can go to a magistrate. He said, I'm available 24 hours a day. And when the parties and the lawyers are convinced that they're going to have to bring their little disputes before the judge is going to have to try the case, I will tell you that the coefficient of nonsense goes way down. If you send it to a magistrate judge to conduct discovery, well, magistrates don't get to do very much other than write discovery opinions. Nobody reads the discovery opinions, but if that's your job, that's what you do. And so it goes to a magistrate. You don't see it for 6 months or a year. If the judge remains involved in actually deciding motions rather than massaging people into settlements, it goes a lot faster. And you can, I mean, the fact is that a jury trial is a lot quicker than a bench trial. People say, well, I'm going to do you a favor, Judge, and waive a jury. No, that's not a favor. You bring a jury in, you pick them in half a day, if that. They go out and decide the case. If you're a judge, you have to write findings and conclusions, which then go to the Court of Appeals. And we know what happens there.
We retry the case gratis.
Right.
Tom?
Well, I'll second what my colleague said. When I was a district judge, I did not use magistrate judges for discovery because I wanted to know exactly what was going on in my cases from start to finish. And in our district, the Western District of Pennsylvania, the new tradition seems to be to use magistrate judges to get consents. And if you have good magistrate judges and the district court is willing to do it, the lawyers, I think, are happy to consent and go with the magistrate judge, because I felt that if you bring the magistrate judge in, you're just doing everything twice. So you do, and I agree with Judge Thapar that I don't think in 3.5 years I wrote an opinion on a single discovery motion, because like him, my approach was, if you have a problem, call me. And we'd resolve it on the phone, and if we couldn't resolve it on the phone, I'd bring them into chambers and we'd sit there off the record and work it out. And if we couldn't work it out, then we'd bring in a court reporter and we'd make a record so that when it went up on appeal, everyone knew what happened. But I think all that requires proactive district judges. So I think, the enemy here is sort of the district judge who sits back in the ivory tower and allows the case to unfold upon him or her without taking an active role. One little potential area of dissent from what I heard is, I hear my trial lawyer Rambo friends paint ADR as the enemy of the jury trial, and the statistics you just saw are just because of ADR, and it's terrible and should be done away with. And of course, my communitarian friends think that, and I've heard some judges say this, some federal district judges say, Anytime I have to put on the robe and go on the bench and put a jury in the box, that's a failure. I think both of those are extreme positions that are wrong. I think ADR should be used as an important tool, and I do think court intervention is required in some way, shape, or form, because if you leave the parties to their own devices, it usually gets acrimonious quickly and they can't get to yes. So I think they need help getting to yes, and the court can serve a good function there as a facilitator. But I think what ADR should be about is the judge identifying early on which cases can and should settle. So you're moving the settlement paradigm from the courthouse steps the day before the jury is in the box and move it as close to the Rule 16 conference as you can. And once you do that and you settle cases earlier and smarter, you've freed up your schedule to try cases quicker and more fairly.
Could I just challenge a little bit, maybe as a devil's advocate, to some of the points that Judge Thapar has put out? So first of all, and I agree with what Judge Hardiman just said about ADR, but it's important to remember that Congress is the body that told us to create these alternative dispute resolution programs and to encourage alternative dispute resolution. And the Supreme Court is who told us to get serious about summary judgment as a way of resolving cases. And, you know, we have to take seriously what the court told us. Now, has it gone overboard, summary judgment? Yeah, I think it has gone overboard. The other thing to keep in mind is that we're not equipped as district court. I love hearing these appellate court judges tell the district courts what they have to do, because the truth is we don't have enough judges to try all the cases. If we went back to a system where we were no longer doing pleas and sentencings the way we are, and we had to try 15 or 20% of the criminal cases that come before us, it would shut us down. There would never be a civil trial. There are districts on the borders that never try civil cases, ever. They have to get a civil case tried. In some of those districts, you have to import judges from other parts of the country. And then I would suggest to you that it might not be true that parties really want juries to decide their cases. If that was true, they wouldn't be building in so many mandatory arbitration provisions into so many contracts that require parties to go to arbitration. A lot of people, particularly on the defense side, don't want jury trials, and they don't want their litigation conducted in a public forum. They want it private. And they have lots of reasons for that, and a lot of good reasons for that. And then the final point I would make is that sometimes juries aren't very good arbiters of truth. They're terrific in criminal cases. They're terrific in simpler civil cases. But juries in patent cases, for example, or extremely complex cases, are really a roll of the dice, and so parties are really concerned about taking highly complex matters to juries. And I imagine there are a lot of lawyers in this audience that feel that way when they're advising their clients.
Michael, did you have?
Yeah, I think the growth of multinational corporations and their involvement in litigation in this country has resulted in a greater reluctance to go to trial than existed before, largely because of the mistrust of the whole jury process. But I disagree somewhat with the notion that juries can't try complex civil cases. I had excellent experience with juries trying complex civil cases. They tried the Trade Center insurance cases, which involved layers of insurance and determining what various riders meant, and they were spot on. I think when they take it seriously and when they're instructed properly and lawyers are kept under control, they can do a terrific job in both civil cases and criminal cases.
Judge Thapar?
Yeah, so I'll respond to a number of the points. So I don't disagree that ADR isn't a good process. What I'd say is I have a problem with judges forcing it on the parties. Having it be an available option for the parties is one thing. Forcing it on them is another, mainly because it reflects very poorly on us, in my opinion. So, of course it's out there, of course it's available. The reason, I totally agree with General Mukasey that juries can try complex cases. You know how they try them? When lawyers do a good job. That's how they do a good job. Lawyers take a complex case and make it simple. The best lawyers in the world, that's what they do. They take a very complex case and they make it easy for a lay person to understand. So juries can do it. We should give them the opportunity to do it. Too often, even judges don't trust juries of doing it, and so they want to resolve it themselves, or they want to push parties to resolve. And my problem is really the battering ram. The other thing is, I totally agree with Judge Smith that district courts are very busy. I say it to my Court of Appeals colleagues all the time, that they need to go try cases. My whole district in the Eastern District of Kentucky, when Texas was flooded with border cases, every judge in the Eastern District of Kentucky volunteered and went down there. We dominated that district court because the judges in Kentucky were willing to go out and do those things. And I think district judges and Court of Appeals judges have an obligation when district courts are overwhelmed to pitch in. All you lawyers travel all over the country doing things, yet we get wedded to our comfortable chambers and don't even want to walk into the courtroom and try cases. So while I'm happy to criticize district judges, I'm also trying a case in 2 weeks, so I'm not here saying I'm not doing it. I'm calling district judges saying, look, if you're overwhelmed, give me a call, I'll come try it. So I think it's important that we remember, we often blame lawyers and parties for the lack of trials without looking at ourselves a lot of times. And so I think that ADR is an option. We should encourage it, but not batter parties with it. And we can let a magistrate judge or someone else encourage it so that the district judge is always available to try the case whenever parties want, and never give the parties a feeling, if you don't try this, I'm going to give you an unfair trial.
Talking about trials, have any of you had any experience with the sort of quickie trials that they're doing in Las Vegas and New York State trials, where the trial could take, perhaps in Vegas, 1 day of trial, 4 or 5 jurors, sometimes an arbitration has been made and not accepted by one of the parties. In New York State, not federal courts, they have quickie trials with an opening statement of 10 minutes, aside a case presentation for 1 hour, modified rules of evidence that allow reports rather than live testimony, and the parties prepare trial notebooks for the jurors. Have any of you had an experience with
those? Those are not binding. Those are advisory, right?
No, they're binding.
They're binding.
Yeah. Right.
Interesting.
I mean, they're agreed upon by the parties, but that becomes a binding judgment.
Yeah, because my experience with juries is it takes them a good day or day and a half, at least, simply to become acculturated to what they're doing there. I mean, they're taken from their daily lives, they're plunked down in the middle of a system they don't understand, and then to have a case put before them and decided in a day, good luck with that. I'm skeptical.
Our district and Ohio did the summary jury trials, is what we called them, and they did it, but it wasn't binding, because I agree with the general. It was a method of alternative dispute resolution that actually had a really high success rate.
Right. Well, shall we
It actually has an even higher success rate when you can monitor the deliberations,
Right.
since it's advisory, and you listen to what the jurors are saying about your case. That has a sobering effect on many lawyers.
Same with questions, by the way, during trial. I allow the jurors to ask questions during civil trials, and that, a lot of cases, because I had a lot more trials once I went from complaint with a year from complaint to trial, and I always, throughout my career, allowed juries to ask questions, and that, it was amazing how about halfway through trial, the light bulb went off, and the parties on their own would settle.
Yeah, I had the experience of having a juror the second week of trial pass a note that said, "What is this case about?" Settlement followed soon after.
That was the point I was making earlier.
Do you let them ask questions, Will?
Yes.
You
yeah,
do?
well, I have done it in the past, but
Yeah, I
then,
never
it gets a
did.
little out of control.
I was sort of like a holdout. I didn't want my jurors having tablets and pens in their hands.
I loved it. And they'd pass up, at the end of every witness, they'd write on the notepad, pass it up. They were so engaged, so involved. They'd pass it up. I'd go over the questions with the lawyers, and then I'd ask them on the jury's behalf. So they never knew which juror was doing it, and we could get the ones that would violate the rules of evidence out or rephrase them. But it was amazing. The lawyers would ask all their questions, and then a juror would ask a question, and the lawyers would both go, "How did I not think of that?"
In my experience, the lawyers objected to all the questions that would have developed any relevant evidence.
Yeah, yeah.
And
Yeah.
the only ones they wanted were frivolous.
Right.
But could we come back? One of the sort of the trends of this dialogue we're having is that I think is sort of counterfactual, which is that we need to do something about this as a problem, that there need to be more trials. We have to solve this problem. And I would suggest that if you look hard at those statistics, you're not going to be able to do anything about this problem. I mean, the decline from the 1960s to the present is effectively a straight, if you plotted it, it's a straight line. And unless we're going to completely change the way we have structured our courts, this is where we are. I don't think we're ever going back to a day when we're going to be trying 12 to 15% of our civil cases and 15% of our criminal cases. It's not going to happen, and we're not built for it. And so, I'm not sure we should be discussing this as if it is a problem that needs to be solved as much as it is a new reality that we need to deal with. Now, should there be more trials? Yes. I would like more trials. I think lawyers would be happier if there were more trials, and I think judges would be happier if there were more trials too. And that could create an institutional problem for us if we don't have more trials, because we rely so heavily on senior judges that if being a trial judge is no longer any fun and all the money is being made in private mediation, when you turn 65, you're going to leave and go out and be a mediator or be a partner in a law firm or do something different because you became a judge to be a trial judge. And we can't make it without senior judges. Senior judges are critical to the way we function.
Let me ask you an impertinent question. Why do we need more trials? Shouldn't it be better if people don't go to trial? Isn't it an abject failure when people have to go to trial?
Yeah, no, I strongly dissent from the notion that it's an abject failure, because not everything can be resolved amicably, and a trial is a beautiful alternative to what Aaron Burr did to Alexander Hamilton.
Right.
And I think any time you can duke it out in the hallowed halls of the federal and state courts, you have a victory. And one of the most beautiful things happened to me during my practice. It was a tiny little case. I was defending a guy who was an excavator with a 7th grade education. He was a great man, and he was sued under the federal labor laws in federal district court for $22,000. And a really wise senior judge with a remarkable amount of trial experience gave my client his day in court. And if he had been one of those judges that Judge Thapar was rightly criticizing, who would take a blunderbuss and force me to settle the case, it would have been terrible. This judge gave my client a trial. He heard all the evidence. And at the end of the evidence, after 2 days, he said, now look, I can do all these findings of fact and conclusions of law, and these lawyers can make all kinds of money, but why don't I just tell you sort of what I'm seeing here? And he basically told my client he was a great guy, but he violated the federal labor laws, and the union damages were ridiculous, and he really should pay them about $7,500. We walked out into the hallway, pulled out a checkbook. He wrote the union guy a check for $7,500. They shook hands, and they went home. That was a beautiful exercise in American civic justice. And if we didn't have a judge with the wisdom to give and you know, these were repeat players, right? The union was upset with my client, and my client felt like he was being beaten up by the union. And there is a tremendous catharsis that can and often does occur in a trial. So I'm all for trials, and I'm for more trials, and I think we can take that number from 0.9% up to 5%. But if I were, you know, able to do something unilaterally, I would probably institute a new federal rule that said all cases worth less than $500,000 will be tried without any discovery.
Can I say amen and be done? The one thing I want to add is we say we can't, and you're right, we're not going to get back to 15%. But I think if you look at the studies, lawyers are less happy. So what Judge Sutton was in charge of the Rules Committee. He championed changing the rules to make courts more accessible. One of the things that Judge Sutton and I talked about is we encouraged people for so long to go to alternative dispute resolution that they thought we didn't want them. And I think it's important that courts have a very open door to people coming in and litigating cases. Over my, nine and a half year time on the district court, I had 150 to 200 cases I tried. Very few were appealed. That speaks to Tom's point. People want a jury trial. There is some wisdom in our founders, right? This is the Federalist Society. We do believe in what the founders thought. The Anti-Federalists crusaded on a jury trial. The promise in Federalist 83 from Alexander Hamilton was that there were going to be jury trials. It's important we remember the wisdom. They were pretty wise, right? The Constitution still exists, and some of us still like interpreting it the way it was meant to be. And so that is an important right. And I think lawyers need to remember to force judges to remember that. There are a lot of new, great, originalist judges. These arguments are out there to be made. And so, and Justice Thomas sometimes writes about this. And I think it's important that we remember the wisdom and we offer to the public the opportunity to try cases, because a lot of them leave happy or sad. If you give them a trial within a year, so I'm with Tom, under 500,000, let's do that. Let's put that in the books. You know how much happier lawyers will be? You know how much happier clients will be? How many clients do any of you have that say, thank God we had a year and a half of discovery?
And how many clients win and the judgment they earned was less than the fees they paid their lawyer? Right? That's a Pyrrhic victory.
Well, I would just, I can't really disagree with a lot of what you're saying, but I don't see the problem as the judges. Most of the judges I know want to try more cases. They don't want to do discovery either. They don't want to, as a trial judge, I love being a trial judge, and one of the things I like about being a trial judge is trials. So, you know, it's very frustrating not to have trials, and I think it's going to result in more judges retiring as soon as they're eligible. So, I'm not sure it's a judge problem. I think it's a lawyer problem as much as it is anything else.
Can I ask a question? Because I think it's as much a judge problem as a lawyer problem. How many of you have had a case that you wanted to go to trial where the judge battered you until you settled? Yeah. I think there's...
Many.
No, that's a decent amount. Look, it should never happen, is my point. And there were enough out there that wanted to go to trial.
It's corrosive of a judge's function to be, as you put it, battering people into settlement. But it is also destructive, I think, of lawyers' skills to have that many cases or that proportion of cases settle. How can a lawyer possibly advise a client on what the risks are of going forward if that lawyer has never tried a case? And yet there are people becoming partners in substantial firms in the litigation department, of all things, who have never tried a case. I had the experience when I was in practice, before I went on the bench, of having somebody come into my office and sit down and try to make the case for making one of our associates a partner. And I said, but he's got no stand-up experience. And the response was, oh, he's not a trial lawyer, he's a litigator.
Well, and on that point, in my experience, the fastest way to force, you talk about battering lawyers to settle, the fastest way to get lawyers to settle is to set a firm trial date.
Right.
That's when they settle, because they're afraid of going to trial, or their clients are afraid of going to trial.
And the result of a lot of this is that in the cases that do go to trial are in substantial part the ones where a plaintiff, for example, has nothing to lose. You get a pro se prisoner who manages to survive summary judgment. He gets a free trip to a much better prison than the one he was in. He gets to see his friends and relatives, and he may get some money.
Now that you brought up people who have nothing to lose, I think it's a perfect segue to the criminal law. Could we talk about what the effect of, for instance, lengthy sentences on plea bargaining has been, and any other subjects which have caused a drop in criminal trials?
Well, I think it's pretty obvious that what caused the drop-off in criminal trials was the institution of the guidelines, which is interesting because when they first went into effect, and I was sitting at that time, everybody predicted that nobody would plead because they were so draconian that everybody would go to trial, whereas quite the opposite happened. They appear to have. One view is that, well, they gave the criminal classes what their lives always missed, which was structure and predictability. Here's what you get if you go to trial. Here's what you get if you plead. There's a lot more to it than that. Part of this is driven by mandatory minimums, and the only way you can get out from under those is to provide substantial assistance to a prosecutor. And so prosecutors make charging decisions. Those charging decisions substantially control the outcome. And as a result, lawyers increasingly try their cases in the Assistant U.S. Attorney's Office rather than in the courtroom.
What has been the effect of Booker, which made the sentencing guidelines advisory? Well, you're
Right. Well, if you look at the statistics, the decline has been consistent and very steep from about 1992 to the present. But with Booker, which happened in 2005, and then there was some follow-on case law development that didn't really settle down until about 2007 or 8. The decline slowed down definitely with Booker, and it's really settled in at around 2.5% of criminal cases go to trial, and we do try criminal cases. I tried one last week. I'm trying one next week, and I'm trying one the week after that. And those cases are going to go to trial. They're not going to end in pleas. There are a number of reasons why people go to trial. Sometimes they're innocent. That's a reason. Sometimes.
How often does that happen?
Well, my trial last week resulted in an acquittal. So
That's different from innocent.
Yeah. Well, true. That's what the prosecutor said.
The verdict is not guilty.
That's what the prosecutor said.
That's a good attorney general right there.
So some cases go to trial because deportation is on the table, and it's not about whether the defendant is looking at 2 years or 4 years. The defendant's looking at being deported, and this is his only chance to stay in the country is to throw the dice. So we get some of those, but still, I think the effect is the Booker has not had a dramatic effect in terms of increasing the number of criminal trials. It may have slowed the decline, but the effects that the general talked about are still absolutely true today, even after Booker. That is, the power of the U.S. attorneys to leverage with mandatory minimums and otherwise is just so great.
Judge Thapar, you were going to talk about the presence of a lot of frivolous appeals on sentencing since Booker.
Yeah, I mean, one thing that happens is this is one area where I'm a big fan in most instances of the hard work district judges do at sentencing. They pay a lot of attention to the guidelines and 3553A factors, and one thing we found, although not uniformly, is that there's a category of sentences where you're sentenced within the advisory guidelines, where it's very hard for a court of appeals looking at a cold record to revisit what a district judge does. And a lot of times, a lot of those appeals flood the courts, whereas there are some meritorious appeals. Judge Kethledge had to reverse a district court twice for giving a child porn person 1 day. And so there are appeals outside the heartland where I think courts of appeals have a significant role in paying attention, both going up and going down, and making sure that people are fairly sentenced. But what tends to happen a lot is in this day and age, as Judge Smith pointed out, where there's a lot of plea agreements, the only thing they reserve appealing is their sentence. District judges are very careful and thoughtful, in my experience, in going through the factors and making sure the sentence is fair and just and within the heartland. And then it's very difficult for courts of appeals to do anything. I don't know if Tom's had a different experience.
I see it exactly as you do, Amul. Booker's effect primarily has been on the prolixity of sentencing hearings now. And that sometimes is triggered by the overzealous circuit court review of what the trial judge did. And there's an interesting dialogue on our court about those who were and those who weren't. Those circuit judges that were trial judges and those who weren't, and what degree of scrutiny is given to the sentence. And as for Will's point...
Those are the two worst kinds of circuit judges, by the way. Those who were and those who weren't.
What's the alternative? And for what Will said, I agree. Booker's had no impact on trials. A great percentage of the criminal trials I presided over were mandatory minimum cases where the defendant had little to lose, might as well take a shot kind of cases.
And the innocent defendants, right, General?
Yes.
Right.
They're not guilty.
Both of them. It's interesting to think about how all of this started. Time was that the only rule for sentencing is that there was a maximum that was prescribed in the criminal law, and a judge could sentence to anything from 0 to the maximum, and that was accepted as kind of one of those oddities of life. But a district judge, as a matter of fact, in the court on which I used to sit, named Marvin Frankel, wrote a thin book, it's less than 200 pages, called The Crime of Sentencing. He did that in the 1970s. And he recounted stories about disparities in sentencing and about arbitrariness in sentencing, including stuff that he heard at the lunch table, I guess, at the courthouse, where one judge said, I was going to give this guy 5 years, but he came in and delivered this tirade to me about how unfair his trial had been. So I gave the SOB another 5 years, tacked it on. And of course, the scandal was the guy never knew it. The defendant never knew it. There was that kind of scandal. And then, of course, there was the untruthfulness, essentially, of the sentencing, where somebody would come in and get 10 years or 15 years, and there'd be a headline, Mr. X or Ms. X got 15 years in jail. And then it would go to the parole commission, and they would let him or her out within a relatively short period of time. And there were judges who felt that, a parole commission doesn't have anything to tell me about what's a fair sentence and what isn't. And so to bring in uniformity and what was called truth in sentencing, the guidelines were put into effect, no more parole, and supposedly uniform sentences. I say supposedly because I think that promise has been breached more often than kept. The bringing of charges is what controls the length of the sentence. And sometimes, it's not really a scandal for people to get different sentences in different parts of the country for the same act, because the rip that's made in the social fabric in one place may not be the same as the rip that's made in another.
Is there any variance in the sentences that are being handed out by younger judges and older judges, the ones that were around before the sentencing guidelines when it came in? What about that?
I don't know that there's been enough time to really study that, but there definitely are variances that exist geographically, for example. And the Sentencing Commission reviews and produces data on this that is really, really detailed and really terrific. So that's a bit of a concern. I know in our region of the country, up in the Northeast, we vary from the guidelines probably more than any other part of the country. In the South and the West, they do so less, and there's a lot of in between, and it can be sliced and diced down to the district, and there's great controversy over whether it can be and should be looked at even by judge, and that's an issue that has been kicking around a little bit. I do think that we are going to have a generation of judges, maybe soon a majority of judges who came onto the bench after Booker. Booker was 2005, so we've had 13 years of appointments now with judges who didn't know what it was like to sentence people under a mandatory guideline system. All of us, well, I think you came on in a little around that time.
Right, I'm after.
After Booker. But Tom and I were, and General Mukasey definitely sentenced people during the mandatory guideline era, and I will tell you that it was, in my view, it was miserable business, and I am so thankful every day that I have my discretion now to not impose sentences on mandatory sentences under the guidelines. It's really brought home to me when I visit prisoners, when I go to prisons, and I've gone to many of them. I visit the people that I've sentenced, and it's a moving experience to have 10 or 15 people stand up and ask you, what the hell am I supposed to do with my life when I get out of prison after the 20 or 25-year sentence that you gave me, and it really doesn't make them feel much better when you say, well, that was before Booker, and if it was after Booker, you know, I just let you know that would have only been a 3-year sentence, not a 20-year sentence. It really doesn't make them feel much better. So, you know, it's now we'll have a whole generation of judges who've had discretion right from the beginning. Now, how will they be? I mean, I do a lot. One of the things I do for the Federal Judicial Center is mentor new judges. I've mentored classes of judges appointed by President Obama, and I've mentored classes appointed by President Trump. I'm mentoring a class in January, and there is a difference for sure in coming onto the job on how they view sentencing issues as they're taking the bench. I think how you feel about it when you take the bench is often a little different than how you feel about it after you've done it 5 or 10 years. So the judges will evolve.
How do these mandatory minimums affect plea bargaining, in your idea?
Well, I mean, they give all the leverage as opposed to just most of it to the prosecutor.
I just had 2 quick addenda to what Judge Smith just said. I think one salutary change brought about by Booker is that cases decided before Booker had some really sort of errant and bizarre guidelines interpretations that I could conclude only that the district judge was doing everything he or she could to get out from under a mandatory guideline. So I feel like the work of the district courts now is a lot straighter and cogent regarding the interpretations of guideline enhancements or reductions. And then the other thing I'll mention is, in addition to the geographic disparities mentioned by Judge Smith, there are these disparities within certain categories of cases. And I think three notable ones about which a fair amount's been written are fast-track jurisdictions. Not every, of the 94 districts adopted fast-track, few did. And that can be great disparities, wide disparities in child pornography sentencing because the guideline ranges tend to be quite high in that area, and also career offender disparities. So in addition, I agree that regional disparities exist, and I think sometimes for good reasons, as General Mukasey identified, but there are also these sort of disparities based on certain categories of cases.
Okay. Well, if there's no further comments, I think we'll open up the floor to questions. Please state your name, and please state it a question, not
I'm Steve Calabrese, co-founder of the Federalist Society, and I found this discussion extremely interesting. I had three questions. One is, I was fortunate enough to be working for Attorney General Meese when the sentencing guidelines were approved as law, and some of us at the time felt that there should also be charge guidelines issued to the U.S. attorneys to try to guide their discretion in charging defendants. I don't know if that could be effectively done, but I wonder what any of you might think about that. Second, an issue that comes up all the time now with district court nominations is that the ABA criticizes the district court nominees for having insufficient trial experience. It's obvious why judicial nominees to the district courts have insufficient trial experience. There aren't that many trials going on. I don't know who should tell the ABA that this is happening, or what the ABA should be looking for instead of trial experience in terms of ranking judicial district court nominees, but clearly something should happen. And then my third and biggest question is, there's been a huge increase in the caseload over the period of time that Judge Smith identified. I know that since 1991, the caseload in the federal district courts and the federal courts of appeals has at least doubled, and there have been no new Article III judgeships created since 1991. And obviously, if you double the caseload or triple the caseload and you leave the number of judges the same, the judges simply aren't going to have time to try cases, and so alternatives to trial are going to emerge. I have previously written an op-ed arguing that there should be perhaps a doubling of the number of district court judges. And at the Court of Appeals level, I think there's a similar problem, which is that when I clerked on the Courts of Appeals, only about 20% of the cases were decided by unpublished memorandum opinions. Currently, about 90% of the cases on the federal Courts of Appeals are decided by memorandum opinions. Now, given the politics surrounding the creation of judgeships, the only way a judgeship bill could pass, if one even wanted it to pass, is for it to phase in perhaps over a 10-year period of time, with additional judgeships being created every 2 years. There's obviously a cost in having more judges. It creates more complexity and more difficulty in interacting, but it might at the same time allow for the trial of more cases. I'd be curious to your answers to any of those questions.
I'd like to exercise my authority as moderator to answer your second question about the ABA criticisms. My standard response to the ABA when I get a letter is, I'll have nothing to do with you. Does anybody want to talk about charge guidelines? And
I'll demur on that.
I think it's a terrific idea, and particularly given the presence of the sentencing guidelines. It is one thing to have sentencing in the hands of somewhat older, more stable people who don't have any experience, but to have those decisions in the hands of kids who've never made a mistake in their lives, or so they think, is worse yet. So I'm all in favor of it.
I'd be in favor of charge guidelines as long as the there was discretion associated with them. Well, one of the most frustrating times for me as a judge was during the Ashcroft era, when the so-called Ashcroft memorandum went out, which required prosecutors to charge to the highest possible sentence, and that resulted in a lot of what we call 851 allegations being made, which could double and ultimately double mandatory minimums and lead to life sentences for drug offenses, and that really tied the hands of prosecutors in a way that was very frustrating to judges and frustrating to defense attorneys and frustrating to the prosecutors too. So I would not be in favor of that kind of thing. So, if you have any thoughts.
I'll just speak to your third point, Steve. Increasing caseload, sure. Increase judges or reduce federal jurisdiction. Right. I mean, I think that's largely just the ever-increasing federalization of everything is what's caused those numbers to dramatically increase.
That's an excellent point.
Amen.
Just on the
Can I
point
say
about-
that again?
The point about increasing
There
judgeship.
is a silver lining from the Ninth Circuit. Our caseload has actually decreased about 15% in the last 3 or 4 years. And I was talking to a judge who will not be named from the Seventh Circuit, and he told me that they're getting new judges and fewer cases to the point where they're going to be dark in January.
And one addendum too is put in a plug for technology, since I do a lot with the federal courts and technology. Judge Aldisert in his 90s mentioned that when he came on in the 60s, the Third Circuit judges were deciding 60 cases per year per active judge. In the same year, he told me that we were doing 420 decisions per year per judge. And we weren't anywhere like 7 times smarter than our forebears, but rather the technology has just given us a remarkable power to work more efficiently and than they were in the typewriter era and the Shepard's era. Remember Shepard's?
Shepherd books.
Do the three,
All the young lawyers
Shepardizing,
don't.
yeah, Shepherd. I said to a clerk once, "Why don't you Shepardize that case just to see the reaction?" I got nothing. They wanted to talk about the categorical approach and the Shepard documents. I was like, no, it's a totally different thing.
just out of curiosity.
Could I come back to this ABA point that Steve mentioned? I think this is a really important point. There's a mythology about finding people who can be district court judges, that there has to be this great body of trial court experience for one to be a good trial court judge, and it's a total myth. And that, in my view, I think it's a total myth. I was a labor lawyer. I didn't try cases to juries. I did the trial by ambush that you all want to go back to. That's what I did. I tried lots of cases, but we never had discovery as labor lawyers. We just tried arbitrations. And you can learn the rules of evidence, and you can learn how to handle a trial perfectly well in a lot of ways. And it just isn't that. Trial lawyers have for generations wanted to sort of create this sort of myth around what they do, that it's combination of art and science, and you just have to be inculcated in it for years and years and years before you could ever possibly understand how to do this business. And it's just not true. There are a lot of people who can be great trial judges. Maybe they wouldn't be great trial lawyers, but they could be great trial judges with proper training. Frankly, I think we ought to worry more about making sure we have smart judges who can learn to do these basic things that we do. A lot of what we do is not rocket science, and you can learn it. But if you're going to handle a really, really complicated patent case and you don't know anything about math or science, and unfortunately I fall into that category, that's a bigger hurdle than running a simple trial.
Let's go to the back of the room.
Trey Mayfield, litigator here in the DC area. Thank you all for your comments. A number of you made in this civil discussion session the point that judges needed to be more hands-on. And I think, at least from my vantage point as a 20-year litigator, I do see that, but I see it process hands-on. I don't see substantive hands-on from the federal judiciary. I had the privilege of clerking in the district court 20 years ago, and I remember my reaction was that 80% of these cases shouldn't be here. The answer is just so obvious. And we have something in the civil rules that's supposed to address that, and it's called Rule 11. And yet, I don't see, and I don't think any of my colleagues see, judges really applying Rule 11 in a meaningful sense. They use it for egregious lawyer conduct, but no one says anymore that there's just some cases that are too stupid to be in court. And I just want your comments on that.
I think that's a valid point. I would say that I never saw, so it's a product of two things, right? And it's circular, is that judges may not grant them because we don't want to grant them against lawyers. Maybe that's, I'm surmising. I never saw a motion under Rule 11, so it takes two to kind of tango, and I think the motions have to be filed. Having said that, I recognize that lawyers are wary of filing it because they're worried judges will come down hard on them. But I actually agree with your previous sentiment that if we could get rid of the frivolous cases, we really could focus more on getting the cases to trial and the other cases to trial. And so maybe that is a tack to take.
Anybody else? All right.
Right.
Next question.
Okay, I'm Mike Doherty, and I'm not a lawyer, so perhaps this might sound naive, but my question is about accountability of judges. I'm from Georgia. We got knocked out from the federal. We moved up on jurisdiction from the Northern District to the Western District of Pennsylvania. And we've had our tolling ignored, even though we were in the wrong jurisdiction. We've had then a recusal, then everything's rubber stamped at the magistrate court. We've not had discovery in 3 years. They have a similar case in the state court in Allegheny County where it's a defamation case where I'm a defendant, and we've had no discovery for over 4 years. Because the plaintiff said he's under investigation by the FBI, and so he needs to plead the fifth, and the judge let that go. And I could just list a nightmare, but that's not the point. The point is when you're in the crosshairs, anything that can happen, anything that can be done. My lawyers are eggshell walkers in Pittsburgh because they just don't want to tick off the judiciary.
I have an easy answer for your problem. I'm in the Third Circuit, and that might come to my court, so I have nothing to say about that.
That's right. Wow, and I liked you until right now.
I'm sorry. Can you phrase your question as a question? What can we do?
Didn't I say that? I didn't ask a question? I just said, what can one do with judges when this type of, in the short term, what can one do? And when you're in the crosshairs,
I think the
or is
answer,
there nothing? It's really about accountability in the big picture.
Right. The answer to your question is that every court has a disciplinary body, which is the circuit conference, and if you feel a judge has handled things in an inappropriate way, you can file a complaint with the circuit court, and it would be assigned to a panel of judges who and a staff attorney who would examine it, and that's the process that we follow.
I was trying to get to a more macro level than me specifically, but I had to give some example. But okay, thank you.
All right, thank you. In the back.
Yes, I'm John Curry. I'm a trial judge in Chicago, Illinois, in the state court system. And one product of the increase in the cost of litigation is, at least in our jurisdiction, an increase in the occurrence of pro se litigation. I'm curious as to whether this is also a factor in federal jurisdiction. It's a serious one for us in the state court that we have developed programs to deal with it. So, A, is it a problem in the federal judiciary? B, what are your strategies for dealing with it? And C, what is the success rate or your opinion as to the worth of those strategies. Thank you.
It's a big issue. I don't know that I identify as a problem, but I can tell you that in 2007, when I joined the Third Circuit, 42% of our cases were pro se, and that number has now gone to about 60%. And a large percentage of those pro se cases are pro se prisoner cases. And Chief Justice wrote an opinion, I don't know, 5 or 8 years ago that was really sort of interesting, where he feared that the proliferation of pro se prisoner cases might put the judiciary in a needle in a haystack situation where some of the really meritorious prisoner cases run the risk of being overlooked by the deluge of unmeritorious cases. So you've identified a very real issue. It's something we're cognizant of. As far as, solution, I mean, we take whatever is filed, so we're not going to have any impact on what cases we get. And, you file a case in our court, it's timely, we exercise jurisdiction. So I'm not sure what the answer is, except that it certainly has increased in our circuit, and it's something that we're well aware of.
Some courts have, and my old court had, a pro se office comprised of lawyers who sit down with pro se plaintiffs and try to translate their complaints into something coherent, analyze them, and then present them to usually the chief judge to sign off on either summary dismissals or putting the case into the docket of a district judge if it has some merit. And that kind of screening device, I think, can be very useful.
I agree, and I just think that it takes, the unfortunate thing is it's a manpower issue. It just takes bodies, and for that you need a budget. And that's the best thing we have to throw at it is our resources.
What we do in the Ninth Circuit, and we have at least 50% of our cases are pro se on the appeals, we first have them screened by our staff attorneys, and they prepare a short resume of the important issues in the case. And then we have a panel of 3 judges that meet by either in San Francisco or in Pasadena or in different places on television. And we discuss each one of these cases and attempt to come to a conclusion that day. We usually do about 150 cases a day. Next question.
Hi, my name is Devin Watkins. So it seems to me, just considering civil cases, it seems to me that the old way of doing things was that when the parties come with a factual dispute that they can't agree, that this would almost always go to trial. But more often today, you see the judges kind of look at discovery and go, in my opinion, no reasonable jury could conclude that the facts would be anything but this. And so you never actually get to a trial because it can get done by summary judgment then. Do you think that in some ways undermines the right to a jury trial to have judges be making those calls?
Do you mean during summary judgment when motions are filed?
During summary judgment, they say, in my opinion, no reasonable jury could conclude any facts but such and such, even though the parties disagree as to what the facts are.
So I wouldn't be comfortable opining because I think it's an argument someone could make. I can tell you, and you probably are aware by asking the question, that there are law reviews written on this, both by a professor from the University of Illinois who takes the position you're at least indicating, and Brian Fitzpatrick, who's also a very thoughtful scholar from Vanderbilt, who says summary judgment's perfectly permissible. But I think it's an interesting argument, and I just haven't done the research, historical research, to figure out if that's there. But I think, again, got a lot of new judges who are willing to look at originalist research. And if it's in the interest of your client to make it, you might want to.
In the back of the room.
Thank you. My name is John Baroni. I'm a retired Supreme Court Justice, New York State, which meant I sit in what everybody else would call a Superior Court in Bronx County. I have 2 questions to ask. One related to the civil trial. As a Bronx judge, as a Supreme Court Justice, you did a fair amount of summary jury trials. Just to clear up some certain things, The effect was the same as binding arbitration. There was a very little chance for appeal. It was done by preparing trial books for the jury. The defendant, each side has a limited time to present its case, usually an hour or an hour and a half. Cases were presented before lunch. The jury usually, but not always, was not compelled to come to a verdict that day. They sometimes came back the next day. And it was all fee-driven. It was all accident cases generally, where policies were $25 to $50 or $50 to $100,000 insurance policies, where it wasn't economic for the plaintiff to proceed to a full jury trial. Some jury insurance companies consented to that. Others did not, and the city of New York did not.
Can we get to the question, please?
Yeah, I'm getting to it right now. I got another one, though, you know. The question is, when you were talking about the federal system, what kind of, is there an availability, or do you think a likelihood, or an advisability to have some sort of summary jury system in the federal courts? And my second question deals with, and I'll be brief. My experience has been with the sentencing guidelines that you must consider, and I hope you can answer the question. You must consider the pressures on a civil or white-collar defendant because the prosecution has tremendous weapons. They can essentially give a get-out-of-jail-free card to every witness except the person they want to get. They can threaten prosecution of family members, and they can bankrupt the defendant. And so there is a possibility, I think, and we should comment on that, there is a possibility of an innocent person taking a year in jail with maybe 6 months house arrest, as opposed to spending $1 million on defense, running the risk of being convicted, and getting, let's say, a 10-year sentence under I know these were pre-Booker cases that I was aware of, but even under the post-Booker cases, of getting a much longer sentence in the federal courts. And it is a temptation, I believe, and you can tell me what you think about it. It is a temptation for an innocent person to take a guilty plea.
Does anybody have a comment on
I mean, summary jury trials, sure. I view it as a form of ADR, and if it's a form of ADR that both parties like, then fine, great. But I still think the better solution, increase in the trials, is to get to trial quickly without discovery and have a trial that's not a species of ADR. And again, I'm very much in favor of ADR, but if you're going to try the case, I'd rather have it be a trial.
I understand. I mean, that's, you know.
And last question from you, sir.
Yeah.
I'm sorry, I had that second question about the likelihood of compelling
I mean, that's an
guilty
inherent risk
pleas
in
from
every
innocent,
criminal case.
particularly white-collar criminals.
Yeah, look, the risk of an innocent person coming in and pleading guilty, as was pointed out to me just a minute ago by Judge Hardiman, is an inherent risk in any system. We place defendants under oath at the time they enter pleas, such that they have to swear that they did what they say they did. Now, other than that, it's difficult to figure out how to create a perfect system.
I agree. Thank you.
Yeah, I'll keep it really short. The Constitution limits federal jurisdiction to cases and controversies, but overwhelmingly when a case arises on appeal, it goes as a matter of law, and sort of the facts are taken for granted from the lower courts. And the Supreme Court almost never takes a case to reverse error. It's mostly like it's causing a circuit mess of some kind. So if the fact gets lost in like the lower courts and the case rises only as a matter of law, like and the Supreme Court says that it's not like taking a case just to get rid of an error made by the lower court, to what extent does that attitude sort of affect the way lawyers look at the case at the beginning, or the way trial judges approach a case?
think part of what you're saying is that, in some respects at least, the trial court is the court of last resort, i.e., the facts. And I think that burden rests on every district judge. I will also tell you that it is a maddening complaint by district judges that, contrary to what you just said, there is often fact-finding in the Court of Appeals, and they get a case back and don't recognize the opinion as being the case that they tried.
That's why we distinguish between those who were and those who weren't.
Right.
And with that,
Amen.
I'd like you to thank this swell panel for me.